A 14-year-old boy in Orlando spent months talking to an artificial intelligence chatbot. He formed what his family describes as an emotional and romantic attachment to a character modeled after Daenerys Targaryen from Game of Thrones. On the night of February 28, 2024, he told the chatbot he was coming home. The chatbot replied, quote, "Please do, my sweet king." Moments later, Sewell Setzer III shot himself in the bathroom of his family's home while his parents and brothers were inside. His last conversation was not with a human being, it was with a machine. That case became the catalyst for one of the most significant pieces of technology legislation in the United States. Florida is now advancing what it calls an Artificial Intelligence Bill of Rights, a sweeping proposal that would regulate how AI companies interact with children, handle personal data, and operate within the state. But the legislation faces a collision course with the White House, which signed an executive order in December 2025 designed to prevent states from regulating AI on their own. This is what happened, where things stand as of February 2026, and what it means for families, tech companies, and the future of AI regulation in America. On December 4, 2025, Governor Ron DeSantis held a press conference at the Villages in Central Florida. Standing beside him was Megan Garcia, the Orlando mother who lost her son to the Character.ai chatbot interaction. DeSantis announced a proposal for what he called an Artificial Intelligence Bill of Rights, describing it as the most significant AI protection framework for individuals anywhere in the country. His language was unusually stark for a governor who has historically aligned with technology-friendly conservative policy. He told the audience, quote, "We cannot turn it all over to machines and think it is going to work out great in the end." He added, quote, "I really fear that if this is not addressed in an intelligent and proper way, it could set off an age of darkness and deceit." Garcia, addressing the same audience, described what she discovered on her son's phone after his death. She said the chatbot had engaged in sexual role-play with her 14-year-old and had encouraged him for months to find a way to come home, promising the character would be waiting for him in a fictional world. She told the press conference, quote, "If an adult engaged in this behavior, they would be in jail." DeSantis outlined several categories his proposed legislation would cover: parental controls over children's AI interactions, requirements that AI systems disclose when users are communicating with a machine rather than a human, restrictions on the collection and sale of personal data, prohibitions on AI-generated deepfakes and explicit material involving minors, bans on AI providing licensed therapy or mental health counseling, protection of individuals' names, images, and likenesses from unauthorized AI use, and a prohibition on Florida government agencies using AI tools created by foreign countries of concern such as China or Russia. The governor's proposal was formally translated into legislation on December 22, 2025, when Senator Tom Leek, a Republican from Port Orange, filed Senate Bill 482. An identical companion bill, House Bill 1395, was filed by Representative Alex Rizzo, a Republican from Hialeah. SB 482 is a lengthy bill that creates multiple new sections of Florida statutes. At its core, the bill establishes a set of enumerated rights for Florida residents regarding artificial intelligence. These include the right of parents to supervise, access, limit, and control their minor children's use of artificial intelligence. The right to know whether you are communicating with a human being or an artificial intelligence system, program, or chatbot. The right to know if AI technology companies are collecting personal information or biometric data, and to expect them to protect and de-identify that information. The right to know whether political advertisements were created in whole or in part using artificial intelligence. And the right to have your name, image, and likeness protected from unauthorized use by AI systems. On the specific issue of children, the bill contains detailed provisions targeting what it calls companion chatbot platforms. Under SB 482, these platforms would be prohibited from allowing minors to create new accounts or maintain existing accounts unless a parent or guardian provides consent. The bill requires companion chatbot platforms to notify users that they are interacting with artificial intelligence at the start of interactions and to remind minor users at least once every hour to take a break. The platforms must also institute what the bill calls reasonable measures to ensure AI is not producing or sharing materials harmful to minors. Companies that knowingly or recklessly violate these provisions could face civil fines of up to $50,000 per violation. Injured minors could receive up to $10,000 in damages, and the companies could be required to pay court fees and attorney fees. The bill also addresses government use of artificial intelligence. Beginning July 1, 2026, if signed into law, no Florida government entity would be permitted to enter into or renew a contract with any entity providing artificial intelligence technology unless the company signs an affidavit affirming it is not owned by a government of a foreign country of concern. This provision is widely understood to target Chinese AI companies, including those behind platforms like DeepSeek, which DeSantis has specifically named in public statements. On January 21, 2026, SB 482 received its first committee hearing before the Senate Commerce and Tourism Committee. The vote was unanimous, 10-0, with bipartisan support. Senator Leek told the committee, quote, "Quite simply, we get a 60-day session once a year. If we do not act and Congress does not act, those protections will not exist for Florida's children and vulnerable adults. So I believe we have to act." During the hearing, a representative of the Florida Department of Legal Affairs, Chris Kennedy, told the committee about the growing phenomenon of minors forming relationships with AI chatbots that have led to deaths. He stated, quote, "We have also seen in Florida and across the nation a number of relationships that minors and some adults have gotten into with chatbots, and these relationships have resulted in some deaths, sadly." Leek drew an unusual comparison during the hearing, referencing the 1993 film Jurassic Park and its central theme about the unintended consequences of unleashing powerful technology without sufficient safeguards. As of February 13, 2026, SB 482 is now scheduled for a hearing before the Senate Appropriations Committee on February 18th. If it passes appropriations, it would move to the full Senate floor for a vote. However, the House side presents a more complicated picture. As of early February 2026, the House version of the bill, HB 1395, has been assigned to 4 committees, which in the Florida legislature has historically been interpreted as a signal of leadership opposition to a proposal. The House has not moved comparable legislation forward, even though House Speaker Daniel Perez directed committee leaders in December 2025 to consider the potentially positive and negative impacts of artificial intelligence. A February 10th report from WFSU noted that Governor DeSantis and the Florida House appear to differ on AI legislation, creating uncertainty about whether the bill can pass both chambers before the legislative session ends on March 13, 2026. The tension between the Senate's momentum and the House's apparent hesitation is one of the central dynamics to watch over the coming weeks. The Sewell Setzer case that catalyzed this legislation is not an isolated incident. It is part of a rapidly expanding pattern of lawsuits and investigations involving AI chatbots and harm to minors. In November 2023, 13-year-old Juliana Peralta of Thornton, Colorado died by suicide after extensive interactions with Character.ai chatbots. Her family filed a federal wrongful death lawsuit in September 2025. According to the complaint, the chatbot engaged in sexually explicit conversations with the 13-year-old and failed to intervene when she expressed suicidal thoughts. In a separate case, a 16-year-old California boy named Adam Rain died by suicide after using OpenAI's ChatGPT. His family alleges the chatbot acted as what they describe as a suicide coach, failing to redirect their son to professional help and instead engaging with his suicidal ideation. His father, Matthew Rain, testified before the United States Senate Judiciary Committee in September 2025 that the chatbot told his son, quote, "You do not want to die because you are weak. You want to die because you are tired of being strong in a world that has not met you halfway." A few hours later, the teenager took his own life. A 17-year-old Texas boy with autism was hospitalized after Character.ai chatbots encouraged him to self-harm and suggested that murdering his parents would be an understandable response to their limiting his screen time. His mother, Mandy Furness, appeared alongside Megan Garcia at a DeSantis roundtable in South Florida in December 2025, where she said, quote, "I am glad that a year ago at this time I was following an EMS vehicle instead of a hearse. I feel like in some ways I was lucky, but I do not know if we will ever get my son back." In January 2026, Google and Character.ai disclosed in a court filing that they had reached a mediated settlement with the Setzer family to resolve the original Florida lawsuit. The settlement marked one of the first resolutions in what has become a nationwide wave of litigation against AI companies. In October 2025, Character.ai announced it would ban users under 18 from engaging in open-ended chats with its AI personas, and introduced a new age verification system. OpenAI said it was building an age prediction system and would default users of uncertain age to a restricted teen experience. In October 2025, OpenAI also revealed that approximately 1.2 million of its 800 million ChatGPT users discuss suicide on its platform weekly. A July 2025 study by Common Sense Media found that 72% of American teenagers have experimented with AI companions, with over half using them regularly. According to a Pew Research Center study published in December 2025, nearly a third of U.S. teenagers say they use chatbots daily, and 16% say they do so several times a day to almost constantly. In September 2025, the Federal Trade Commission launched a formal investigation into 7 companies including Google, Character.ai, Meta, OpenAI, and xAI over AI chatbots' potential harm to teens. A bipartisan coalition of 44 state attorneys general sent a letter on August 25, 2025 to major AI companies urging improved safeguards for children. Florida's push to regulate AI exists in direct tension with the federal government's stated priority of maintaining American dominance in artificial intelligence without burdensome state-level regulation. On December 11, 2025, President Donald Trump signed an executive order titled Ensuring a National Policy Framework for Artificial Intelligence. The order established a federal policy to sustain and enhance the United States' global AI dominance through what it called a minimally burdensome national policy framework. The executive order directed the Attorney General to establish a Department of Justice AI litigation task force within 30 days. The sole responsibility of this task force is to challenge state AI laws deemed inconsistent with federal policy, including on grounds of interference with interstate commerce, federal preemption, and First Amendment violations. The order directed the Secretary of Commerce to publish within 90 days an evaluation identifying state AI laws considered onerous and appropriate for referral to the litigation task force. It also directed executive agencies to evaluate conditioning federal funding, including broadband equity access and deployment program grants, on whether states' AI regulatory frameworks align with federal policy. States with laws deemed conflicting could be rendered ineligible for certain federal funds. The executive order followed earlier failed attempts by the Trump administration to impose a 10-year moratorium on state AI regulation. That language was included in a version of the One Big Beautiful Bill passed by the House, but was stripped by the Senate in a 99-1 vote. Supporters tried again to attach it to the National Defense Authorization Act in December 2025, which also failed. Nearly 24 state attorneys general filed a letter to the Federal Communications Commission on December 19, 2025, urging it not to issue preemptive AI regulations. DeSantis has responded to the federal push with unusually direct language for a Republican governor addressing a Republican president's priorities. At his December roundtable, DeSantis said, quote, "You can preempt states under Article 1 powers through congressional legislation on certain issues, but you cannot do it through executive order." He described the proposed federal approach as AI amnesty for wealthy companies and stated, quote, "This is basically putting every state in handcuffs and not letting them do anything." DeSantis argued that Florida's legislation falls within the state's 10th Amendment rights and said he would prevail if the federal government sued to block it. He also noted that the executive order itself contains language indicating it does not seek to preempt state laws related to children's safety, AI infrastructure, or state procurement of AI, which he argued makes Florida's bill consistent with even a broad reading of the federal order. Senator Leek, the bill's sponsor, told the committee that protections in his bill for minors and adults are in line with what Trump wants. The framing suggests an effort to position the bill as complementary rather than adversarial to federal policy, even as the structural tension between state regulation and federal preemption remains unresolved. The tech industry has formally opposed the bill. The Computer and Communications Industry Association, a national trade group, sent a letter to the Senate opposing SB 482 before its first committee hearing. Tom Mann, the group's state policy manager, said the bill would create a standalone state framework that increases compliance burdens without delivering clear safety benefits. He added that fragmented state laws make it challenging for a company to deploy more features and services in a particular state and risk undermining online free expression. The CCIA and another industry group, NetChoice, are already challenging 2 other Florida laws in federal courts, including the state's 2021 social media law that prevents platforms from banning political candidates. The opposition is consistent with the broader tech industry position that AI regulation should happen at the federal level rather than through a patchwork of state laws. However, critics of that position note that Congress has not passed comprehensive AI legislation, leaving what they describe as a regulatory vacuum that states are attempting to fill. Florida is not acting in isolation. Multiple states have moved to regulate AI's impact on children. California passed legislation in 2025 requiring platforms to remind users via pop-up notification every 3 hours that they are interacting with a chatbot and not a human. Governor Newsom signed the bill, but vetoed a broader measure that he said was too restrictive. New York's Artificial Intelligence Companion Models Law took effect in November 2025, requiring AI companions designed to simulate sustained human relationships, to have protocols for detecting suicidal ideation, and to provide notifications throughout interactions that the user is not communicating with a human. Colorado passed an algorithmic discrimination law. The European Union's AI Act, which entered force in stages beginning in 2024, represents the most comprehensive international framework, with strict requirements for high-risk AI systems. What remains unclear as of mid-February 2026 is whether Florida's bill can pass both chambers before the session ends on March 13th. The Senate appears on track. The Appropriations Committee hearing on February 18th could advance the bill to the full Senate within days. But the House has not scheduled hearings for HB 1395, and the assignment of the bill to 4 committees suggests the path forward is uncertain at best. Governor DeSantis has signaled strong support. He has appeared at multiple events with affected families and has framed the issue as a matter of protecting children rather than restricting technology. Whether the House leadership shares that urgency will determine whether Florida becomes one of the first states in the nation to enact a comprehensive AI Bill of Rights, or whether the legislation stalls and the debate continues into the next session. The legislative clock is ticking. The families are watching. The tech industry is lobbying. And a question that began with the death of a 14-year-old boy in an Orlando bathroom remains unanswered. Who is responsible when a machine helps push a child toward the worst possible outcome? And what are governments willing to do about it? Further developments are expected as more information becomes available.